Court does call the case of the people versus Travis Oliver.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Oliver, who stands to my right, please state your name for the record, sir.
Travis Oliver. Thank you. All right, what do we do?
Thank you, Your Honor. There is a resolution in this matter to which Mr. Oliver will be pleading no contest as charged under a prosecutor's deferred.
And that's correct, Your Honor.
Prosecutor's deferred. Yeah, have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
State your name.
Travis Oliver.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of personal property less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
You understand that the fine could be increased to 3 times the value of the property destroyed or otherwise injured. If that's greater than $500, that would become the maximum fine.
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea, counsel.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
You understand that with pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on there.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case 25-1258. Any objection to the court having reviewed that report?
None from the people, Your Honor.
No, Your Honor.
Based upon a review of that report and also the court having heard the testimony in this case, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
Second at 1 p.m.
June 2nd, 2025, 1 p.m. Defendant's bond with its condition.
Yes, sir.
Stop at probation. You're on your left-hand side, stop in there, get the process started. All right.
Okay. Thank you.
All right. Thank you.
Your Honor.
Court does call the case of the people versus Stephen Grisby.
Alexander, on behalf of the people, Your Honor. It is Mr. Burns. Do you want to go check the hallway?
Or you could just sit there, either way.
I just saw him.
He was just back there.
Maybe he went so bad.
Like this happens every time a case gets called first.
Yes.
So here with and on Sam Bernstein with and on behalf of Mr. Grisby, who's present with me.
Your name, sir.
Stephen Grisby.
All right. Go ahead.
Here for sentencing, Your Honor. We were here last week when everyone very graciously and patiently listened to me ask for possible sentence where Mr. Grisby would do the accountable choices program in jail with release on a tether to probation afterwards. And I appreciate Ms. Pilara and Ms. Senda for listening to me, and Your Honor, of course. Mr. Grisby has been trying to get into that program since he got into jail, but he's been really pushing the last 2 weeks with kites and so forth. And they visited him last week and told him that there's 52 court-ordered people in line before him to get into the course, making it the most popular course in Washtenaw County on any given night. So I'm not exactly sure how that's going to play out for him, given how long it would take him to get in there. He'd be doing a significant amount of time before completion. One of the things I've been talking to him that he's concerned about is his Section 8 voucher. He's worked very hard to get it, and he's about a month away from potentially losing it, maybe a month and a half that he worked very hard to get. And he does have a job for the meantime, but we don't know how long with heating and cooling. That it's been a pretty good job for him. So he's gotten some strides going in his personal life that he stands to lose. And I think maybe he could have held it together if he thinks accountable choices would start in the short term, but I just don't know that it is. So I guess we are asking the court to consider maybe like a release to drug treatment in the interim. To get
How long is the program, the in-jail program?
I think it's 13 weeks, Your Honor.
Okay. Did they, did they tell you, Mr. Grisby, you were 52 ahead of you?
Yes, because I wrote a kite and they came back Thursday night and told me that there was 52 people ahead of me. That's with being court ordered.
Got it.
So there's 52 people ahead of me.
So those were 52 that had not started it yet.
I had not started it yet.
Okay. Well, I guess what I'd probably do is order this. I will, if we can find an alternative program with him out that would work for him, then I might consider release.
Your Honor, I can tell you that the program, the in-jail program is offered out. And in my recommendation, I was asking the court to have him complete the first phase in and then continue the full programming out. So that is how.
That's how it's structured. But I guess my question is it gonna take him, does he have to wait through 52 people to do that? And
On the
then,
outside, no.
pardon?
On the outside, no.
Right,
It's a
but
52-week program on the outside.
gotcha. But you want him to do the first phase of the DV program in jail, but he won't at best get to that. I mean, I don't know how many people are in the class, but he won't get to that at least for 13 weeks, probably much longer.
If the court is considering to release him so he can get started with that program on the outside, I would ask that he definitely have that GPS monitor on, so he can do that.
Let's do this. So, Mr. Wilson, did you verify that it's 52 ahead of him?
I have not verified, Your Honor. Mr. Grisby just told me. I'm happy to, I can email Mr. Henderson, who runs the program, or Lieutenant Arnett. Get like a
Here's
better.
what I'll do. I'll order what's here. I need it then checked
Okay.
as to how long it's anticipated before he would get in.
Yes.
And then I'll consider changing the program so that maybe he can complete part of that outside, or complete it outside as opposed to in.
That makes sense. I appreciate that, Your Honor, and I'll send some emails right after court.
All right. Anything else you want to say before I impose that?
No, Your Honor, I don't know if Mr. Grisby had a couple of things he wanted to say.
I just would like to say, Your Honor, I want to take accountability for my actions, and I apologize to the courts for going through this. And I just received my Section 8 housing voucher back in November. And I just got it, and if I do any more than like a month in jail, I will lose my Section 8. And I'm just asking that the courts, if I could do this class and with one, if I, I won't make no mistakes. If I do make a mistake, I have to come back and do the complete jail sentence. I'm asking for one chance. I can't show you that chance if I'm locked up, Your Honor. And I've gotten sober back in October. I've been doing these classes prior to me coming into jail. So I had been sober prior to coming to jail. And I would like to show the courts that I can not get in any more trouble, and that if I complete this class, that it'll make me even better person for today. I want to show the courts that I can do this.
All right. It's a sentence of the court, place you on 24 months probationary term. You're to pay $555 fines and costs, 720 probation oversight fees. I'm going to make that due and payable 45 days after release.
Those emails out.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the in-jail DV program, phase 1, and then remainder of the program, phase 2, after release. That's what I'll order at this time. And again, I would potentially change that if necessary, once we can take a closer look at when he can get in. Continue outpatient substance abuse treatment. Follow all treatment recommendations with status reports to probation. No contact with Samantha Smith, directly or indirectly. You're not to go to the residence or employment of Samantha Smith. You're not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to report to probation as requested by probation, including any home visits. Begin and maintain employment with verification to probation. You are to comply with any circuit court orders. I'll set a review hearing that's to be held July 7th, 2025, 1 p.m. I will order 365 days in jail, credit 40 days served. Defendant to remain in custody until completion of the in-jail Dawn Farm program, or not Dawn Farm, DV program. And then the balance will be suspended with placement on a GPS tether prior to release. All right.
Thank you, Your Honor.
All right, thank you. Can you grab a phone? Court does call the case of the people versus, is it Cyan Taylor?
Alexander, on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Taylor. Ms. Taylor, please state your name for the record.
Cyan Taylor.
Your Honor, we are here for a pre-trial. I'd first ask to address bond, please.
You can go ahead.
Ms. Taylor is being held on a $25,000, 10% bond. She failed to appear at a final settlement conference. I am asking that the court consider reducing her bond to a personal bond. Since then, her life circumstances have changed. She's now in a more stable position, I should say. She, at that time, was essentially homeless. She's kind of bouncing around. Now she's staying with her parents, her family. Her mother is here in the courtroom. She also, at that time, wasn't working. She now has a job at Home Watch as a nurse's aide. She spoke to her mom, who spoke to that, and she will be able to return to that job if released. At final settlement conference, the people were unable to proceed. However, because she was there or not there, the warrant was issued. I don't know if circumstances have changed with the complaining witness at this point, but our intention is to set up for final settlement conference again, depending on the bond, I suppose. But I am asking the court consider changing the bond. She's been in custody now for over a week. How many days?
A week and 3 days.
11 days now.
that she's been in?
Yes.
All right. Well, how did she come into custody?
I was at the gas station and they said they recognized me, that I had a warrant.
Well, I guess my question is, she missed the court date. Why didn't she come in at some point? Because that was back in October of last year.
Did you have a phone?
Not that, no, not on, no. And also mail was going everywhere else. So it was hard keeping track of everything.
Yeah. I don't think, Your Honor, I think she should have.
Today we watched Travis Oliver step into court and make a bold move, pleading no contest to malicious destruction of property under $200. Now, a no contest plea might sound like a simple "I won't fight it," but legally, the court treats it as guilty. That means no trial, no jury, and yes, potential civil liability is still on the table. Travis avoided courtroom drama, but the stakes were real, up to 93 days in jail and a $500 fine. Every word he said mattered. Did he fully understand he was giving up his right to appeal, his trial rights, and any chance to contest the charges? According to the court, he did. And then we switched gears to Stephen Grisby, whose story shows how much courtroom decisions aren't just legal, they're personal. He's trying to access an accountable choices program, but with 52 people ahead of him, life outside the court can't wait. Housing, employment, and stability hang in the balance. The judge has to balance public safety, legal procedure, and real human consequences, decisions that might seem small on paper but huge in reality. So what do we take from all this? Court isn't just about laws and fines, it's about choices, timing, and consequences. A no contest plea might avoid a trial, but it doesn't erase responsibility. And when programs, probation, and personal life collide, the courtroom becomes a crossroads where every decision counts.